Hey, so I had a reply from the Jersey State, um, who I sent a copy of my notice of rescission and deregistration. Um, because obviously my car's from Jersey, so I've kind of just had to inform them that the car's over here, that it's now my private property held under claim of right. Um, and that I've informed the DVLA of this, but obviously at no point am I registering legal titleship or ownership of the car to any government agency. So I sent those original notices last week after I'd had them notarised. And this is the first reply I've had. Now, obviously, it's not England, it's not the United Kingdom. It is Jersey, it is its own state, it is out of the jurisdiction that obviously I'm kind of challenging, but it's still a good practice. I'm having a lot of fun with this. So I'll read the letter to you. This is what the guy said. Thank you for your letter, dated the 23rd of April, received the 24th. I assume from your correspondence that you are no longer a permanent resident of Jersey. I confirm, however, that to circulate legally in a motor vehicle under your control in Jersey, having been disqualified from driving. Now, I forgot I had that. I forgot I was banned in Jersey. It doesn't affect me over here, but yeah. So, in accordance with the sentence of the court, you must first pass the prescribed driving test. I would also note that Jersey has its own legislation and the various acts that you mentioned do not apply in Jersey. I acknowledge receipt of the registration document for my car. I assume that the vehicle is no longer in Jersey and should be removed from the vehicle register. In order that the vehicle might circulate on roads in the United Kingdom, you will have to register the vehicle with the relevant UK authorities. So that was his reply. So he didn't really rebut any of the content. All he kind of said was that it's nothing to do with them. They're a different state, which is fair enough. That's totally cool. He's still going to get a reply from me. So I wrote this one today. Notice to principal is notice to agent, and notice to agent is notice to principal. Dear Mr. This is a courtesy notice, confirming the intentions outlined to you in my previous notice. You have apparently written to Miss Hannah Shotbolt. This is not me. I hereby give notice that you must please address any counterclaims and correspondence correctly to me, the human woman, and not to any titled and or capitalized artificial person, as this relates to the legal fiction created unknowingly and without full disclosure via the registration of my birth by my parents. I'm no longer a permanent resident of Jersey, and my car, identified as blah blah blah, is now my registered private property and is held under claim of right. I agree it should be removed from your vehicle register as it is not a vehicle, legally speaking. With regard to your claim that I must register the car in the UK, if you cannot provide proof of claim in form of counterclaim against the understandings given in my previous notice and estoppel result, you could always attempt to take these conditions into a court of law if you so wish, but they are indeed perfectly lawful. That option is, of course, always your prerogative should you decide to invest more of your corporation's time and monetary resources in this way. Namaste from me. So, I don't know how that was going to go down. I don't think I'm going to get a reply from him. I don't think he's going to reply. But it was fun putting that letter together. I'm having a lot of fun with this. I didn't think it was going to be this much fun. So, anyway, guys, have a great day.